Welcome to the deep dive. You gave us the sources, and we're here to give you that shortcut to really understanding them. Today, we are tackling something pretty fundamental, but also, honestly, a bit weird in contract law: consideration. We all kind of get that contracts, something valuable changing hands. But what if that something valuable is just promising not to sue someone, especially if later on it turns out that lawsuit would have been totally baseless?
Yeah, we're diving into situations where giving up a claim, even a losing one, can still be good enough consideration. It seems counterintuitive.
It really does. But that's our mission today, figuring out precisely when this act of forbearance, giving up the right to sue, counts legally. So to really get this, first we need to lay out the main legal rule about these, invalid claims. Then we'll put that rule to the test with a fascinating case, Feege v. Boehm. We'll use a really structured approach for that. And finally, we'll pull it all together into a kind of diagnostic tool you can use to spot and analyze this issue yourself. Okay, so it sounds like a plan. Let's start with that basic legal principle then.
Yeah.
If a contract hangs on one party promising not to go after the other legally, what's the general rule? How does the law decide if that promise, that forbearance, is actually valid consideration?
Well, you got to look back a bit first because the law really did a 180 on this. Under the old common law, it was pretty harsh, especially regarding children born outside of marriage. They were seen as filius nullius, sort of child of nobody. So a father's promise to pay support, that was seen as just a moral obligation, and morals alone generally don't make a contract enforceable. No consideration there.
Okay, so pure morality wasn't enough legally. What changed?
Legislation, mainly. Statutes started stepping in. Like in our main case today, Feege v. Boehm, there was the Maryland Bastardy Act. That law actually compelled fathers to contribute support. Once you have a law like that, well then a contract where the mother agrees not to use that statute, that promise can be supported by consideration.
I see. The statute creates a real legal right she could pursue.
Exactly. And that brings us closer to the modern standard, the one you'll find in the Restatement of Contracts.
All right, so what's this modern standard look like? What's the test?
It's basically a two-part test, kind of combined. The core idea is this: giving up an invalid claim isn't good consideration if the person giving it up doesn't have an honest and reasonable belief that the claim might actually be valid.
Honest and reasonable. Both.
Yes, both prongs. You need subjective good faith, meaning the person making the claim, the claimant, has to genuinely, honestly believe it's valid at the time. And you also need objective reasonableness, meaning the claim can't be totally ridiculous, it shouldn't be frivolous or vexatious or just obviously baseless in law.
Okay, but wait. That sounds like it could create a conflict right away. What if, science later proves the claim is totally false, but the person honestly believed it when they made the deal? Which part wins, the honest belief or the objective reality?
That is the central tension here. You've hit the nail on the head. The law is trying to balance things. On one hand, courts really want to encourage people to settle disputes out of court. That's a big policy goal. Settlements are good. But on the other hand, they don't want people threatening bogus lawsuits just to, shake someone down for money. So the Maryland court in Feege, drawing on earlier cases, basically said, look, if the parties thought at the time they made the deal that there was a real bona fide question between them, that's enough.
Even if later it turns out there wasn't really a question at all.
Even then, the subjective belief held in good faith at the time of the contract carries a huge amount of weight.
Okay, that really sets the stage. Now we absolutely have to see how this plays out in Feege v. Boehm. This case seems perfect because it pits that good faith belief directly against cold, hard scientific fact. Right. Let's analyze Feege v. Boehm. First, what are the legally dispositive facts? Give us the story.
Okay, so the plaintiff is Hilda Boehm. She claims that back in 1951, she got pregnant after intercourse with the defendant, Louis Feege. She says he even admitted he was responsible. Now, to avoid getting prosecuted under that Maryland Bastardy Act we mentioned, Feege makes a deal with her. It's a contract. He promises to cover all the medical bills, miscellaneous costs, plus pay $10 a week for child support until the kid turns 21.
And the condition for all this was?
The condition was that Boehm would not bring those bastardy proceedings against him. She had to forbear.
Okay, so he starts paying.
Yeah, he pays for a while, makes about $480 in payments. But then, in May 1953, things change. They get blood tests done.
Ah, the blood test. What did they show?
They showed it was genetically impossible for Feege to be the father. He was type O, Bohm was type B, but the child was type A. Medically, that combination just can't produce a type A child.
So based on that science, Feige stops paying.
Correct. He stops the payments.
Hmm.
Then Bohm actually does initiate the criminal bastardy proceedings against him.
But wait, wouldn't the blood test mean he'd win that?
He did. Feige was acquitted in the criminal case specifically because of those blood tests.
Okay, so case closed.
Not quite, because then Bohm turns around and sues Feige for breaching their original civil contract, the one where he promised to pay her if she didn't sue. She wants the rest of the money.
Wow. Okay, that's quite a twist. She loses the criminal paternity case based on science, but then goes back to enforce the civil agreement not to bring that case in the first place. So what was the core legal issue for the court in that civil suit?
The main issue was pretty straightforward. Was Bohm's promise to not start those bastardy proceedings enough consideration to make Feige's promise to pay enforceable? Especially since, the whole basis for her claim, his paternity, was later proven to be factually wrong by those blood tests.
Right. Can a promise to drop what turns out to be a false claim still be legally valuable? What rule did the court apply to decide this?
They applied that combined rule we talked about, the modern standard needing both subjective honesty and objective reasonableness. So, forbearance is good consideration if the person giving up the claim, Bohm here, had an honest intention to pursue it. That's the good faith part. And the claim itself wasn't, completely out there, couldn't be frivolous, vexatious, or illegal. The court specifically said it must not be absurd in fact or obviously unfounded in law.
Okay, this is the critical part then. What was the court's analysis? How did they weigh Bohm's initial belief against the later scientific proof that Feige wasn't the father?
Their analysis zeroed in almost entirely on Bohm's state of mind when they made the contract. That was the key moment. The court basically said, look, there's no evidence Bohm was lying or acting in bad faith at that specific time when she claimed Feige was the father and agreed not to pursue the bastardy case in exchange for his promise.
So even if she was wrong, she wasn't acting fraudulently then.
Right. And critically, at that time, before anyone knew about the blood test results, her claim wasn't absurd, in fact. There was intercourse, she was pregnant, she named him. It wasn't like claiming, immaculate conception. The court also stressed an important policy point. The contract was a way to settle the potential civil consequences stemming from a criminal act under the Bastardy Act. Settling civil claims like this is allowed. And since the deal seemed fair and reasonable at the time and Bohm made it in good faith, the fact that Feige was later found not guilty in the criminal court based on new evidence didn't automatically kill the civil contract they'd made earlier.
So the objective truth discovered later didn't undo the validity of the bargain struck when both parties were operating under different information, or at least Bohm was operating under a good faith belief.
Precisely. The value wasn't necessarily in the ultimate truth of the claim, but in the settlement of the claim as it was reasonably perceived at the time. Her subjective good faith, combined with the claim not being totally unreasonable then, locked in the deal.
Fascinating. It really highlights the importance of that moment of agreement. So what was the final conclusion?
The court upheld the judgment for Bohm. Her promise not to prosecute was sufficient consideration because, based on the evidence presented about her state of mind at the time of the contract, she made the charge in good faith.
Even though science later proved Feige couldn't have been the father.
Even so, he breached the civil contract by stopping payments, and he still owed her the money according to that agreement, despite not being the biological father.
That is a powerful illustration of how contract law views consideration. Timing and belief really matter. Okay, let's try to make this objective test even clearer. We need one of those memorable, maybe slightly out there hypotheticals to really cement this for everyone listening. Right, let's use that combined test. Imagine your neighbor. Let's call him Kevin. Kevin is convinced, absolutely convinced, that the brand new, perfectly normal fence you just put up has somehow, emitted bad vibes that caused his prize pet goldfish, Bartholomew, to get a rare tropical fungus. Sounds nuts, right? Kevin threatens to sue you for $5,000 for Bartholomew's suffering and his own emotional distress. You think this is ridiculous, but to make him go away, you offer him $500 if he promises, in writing, to never, ever bring up this goldfish fungus claim again. He agrees. Now, is Kevin's promise to drop this seemingly absurd claim sufficient consideration for your promise to pay the $500? Let's look at two scenarios. Scenario A, Kevin is, let's just say he's very passionate about Bartholomew and genuinely honestly believes your fence is the culprit, even though medically it makes zero sense.
He's sincere, just maybe not entirely grounded in reality on this point. Or scenario B, Kevin is actually a sharp lawyer. He knows perfectly well the fence has nothing to do with it. He knows the claim is garbage legally and factually, but he figures threatening a lawsuit is an easy way to maybe squeeze $500 out of you.
Okay, these are great. They really help isolate the two different prongs of the test from Feege. Let's take scenario A. Sincere but strange, Kevin. He probably meets the subjective check. He honestly believes the fence harmed Bartholomew. He has that good faith belief, however misguided.
Right, he's subjectively honest.
But he almost certainly fails the objective check. A claim that a normal fence caused a specific rare tropical fungus in a fish. That really stretches credulity. It likely falls into that absurd in fact category. It's arguably so lacking in any reasonable foundation that even his sincere belief can't save it.
So probably no consideration there. The claim is just too objectively unreasonable.
I would think so. Courts would likely say forbearance from pursuing such a bizarre, unfounded claim isn't valuable consideration. It's vexatious, even if Kevin doesn't realize it.
Okay, now what about scenario B? The sharp lawyer Kevin, who knows the claim is nonsense.
Here it's the opposite problem. Lawyer Kevin clearly fails the subjective check. He knows the claim has no merit. He's not acting in good faith. He's acting strategically, maybe even extortionately.
He doesn't honestly believe it.
Exactly. So even if, hypothetically, you could somehow argue there was some minuscule theoretical legal basis, which seems unlikely here, his lack of subjective good faith kills the consideration. A promise not to pursue a claim, is junk, just isn't valuable consideration. The law doesn't reward using the threat of baseless litigation like that. So, again, your promise to pay the $500 would likely be unenforceable.
So in both cases, the $500 agreement probably fails, but for totally different reasons. One fails the objective test, the other fails the subjective test.
That's it. It shows you really need both. You need that sweet spot, like in Feege. Boehm's claim wasn't objectively absurd at the time, even if later proven wrong, and the court found she subjectively believed it at the time. That's the combination that worked.
That makes sense. Her claim, while ultimately incorrect, was grounded in a plausible reality intercourse potentially leading to pregnancy, unlike the fence fungus connection.
Precisely. It wasn't frivolous or vexatious on its face when the deal was struck.
Okay, this has been a really deep dive. Let's synthesize this for the listener. If you're facing an exam question or just trying to apply this in practice, what's the step-by-step checklist? How do you diagnose whether forbearance counts as consideration?
All right, here's your mandatory diagnostic checklist. Run through these steps systematically. Step 1. Identify the promise and the underlying claim. First, figure out exactly what the person promised not to do. Was it not suing, not prosecuting under specific statute, not filing some other kind of claim? And what was that underlying claim about? Get specific. Step 2, locate the statutory and legal basis. This is crucial. Was the underlying claim completely baseless in law? Like, was there no legal theory that could possibly support it? Or was there a statute like the Bastardy Act and Feege or some other legal principle that gave the claim at least some colorable basis, some potential legal hook, even if the facts didn't ultimately support it?
So check if there was any potential legal path for the claim.
Yes. Because if the claim is obviously unfounded in law from the start, it's much harder to argue it was objectively reasonable to pursue it. Step 3. Apply the combined test, the Feege statement test. This is the heart of it. You must look at the situation at the time the contract was made and check both prongs. First, the subjective check, good faith. Did the person giving up the claim honestly, genuinely believe their claim had some validity back then? No fraud, no bad faith intention. Second, the objective check, reasonableness. Was the claim itself, viewed from the perspective of that time, not frivolous, not vexatious, and did it have some reasonable basis? Was it not absurd, in fact, or obviously unfounded in law?
Both have to be true at the time the deal was struck.
Correct. Both must be met. Step 4. Conclude. If you find that both subjective good faith and objective reasonableness were present at the time of the agreement, then the forbearance is sufficient consideration. The resulting contract is likely enforceable, even if evidence discovered later proves the original claim was actually invalid or would have failed.
That's a fantastic framework. It really emphasizes that the law, in this context, sometimes prioritizes the certainty and finality of a bargain made in good faith over the absolute objective truth discovered later.
Exactly. The policy favoring settlements made honestly is very strong. And understanding why the court in Feege prioritized Boehm's subjective belief, coupled with objective reasonableness at the time, over the later blood tests is key. It's not just about the facts, but the legal reasoning and policy behind the rule.
Okay, let's leave our listeners with a final thought to chew on. Building on this, here's something provocative. What if Louis Feege, the defendant,
had found out about those blood test results before he signed the contract, promising to pay Hilda Bohm. If he knew he couldn't be the father when he made that promise, would the contract still have been enforceable against him? Think about which element of that two-part test might change. Would it affect Bohm's subjective belief, or the objective reasonableness of her claim from her perspective? Or does Fige's knowledge introduce a different element entirely, maybe related to mistake or disclosure? Lots to consider there about timing and information asymmetry. We'll leave you to mull that over. Until the next deep dive, keep learning.